Hacking, the matter of Lifestyle, Equities and another, and Hornby, and other.
Yes, Mr. St. Quentin. I can tell you that we have read the judge's judgment and the skeleton arguments.
I'm grateful, my lord. I hope that will certainly be enough to get things started. I'll take you through any other documents that I think are necessary for you to look at in the course of my submissions. As you'll know from those, of course, by way of preliminaries, I appear for the appellants in this case, my learned friend Miss Lane, for 3 of the defendants, the 3rd, 4th and 8th.
And it's agreed the other defendants stand or fall with these defendants. Precisely
so, my lord, yes. The appeal arises out of a claim issued in June 2020 alleging trademark infringement and passing off. There are various trademarks alleged, but by and large they all relate to the protection of a logo mark that consists of a polo player riding a polo pony surrounded by the words Beverly Hills Polo Club. You've seen it in the
seen it. The judge illustrates them, and there are some word marks.
There's a word mark as well for Beverly Hills Polo Club. Principally, the claim concerns the logo marks. If I may begin, I'll take you through some of the chronology of the background of the dispute, because that's relevant to certain issues that arise in the appeal. There is an agreed chronology in the core bundle at tab 5.
Yeah.
And if I may, I'll briefly take you through some of the points that arise in that. It's page 67, the first page of the chronology. I begin with the 3rd entry, which is that in 1986 there was an application for a UK trademark by a US entity, Gregory Lang Inc. And that was assigned in 1989 to an entity, BHPC Marketing Inc. Now, that entity owned the marks, owned that UK mark, and then later applied for some EU trademarks, which you see in the following 2 entries, 96 and 97.
Yes.
And then, importantly to this appeal, around that time, a dispute arose between that entity, BHPC Marketing, and the parties that my learned friend represents, who I'll refer to as Santa Barbara. The dispute was compromised by an agreement dated June 1997. That's called the 1997 agreement in the judgment, and that's the
agreement on which this all turns. Yeah,
quite so, my lord. Now that following that, you see certain rights that related to Asian trademarks were transferred to a different entity, and then after another EU trademark was filed in 2004, there was an assignment away from BHPC Marketing, who was the party to that 1997 agreement with Santa Barbara, to an entity, BHPC Associates Limited.
Yeah.
Now, that was an entity in which one of the moving individuals behind my clients was involved, but his evidence was that at that stage and at no stage afterwards until about 2013 was he or either of his half-brothers who were also involved in BHPC Associates aware of the 1997 agreement. At some later stage, 2008, as you see by the second hole punch on page 67, Mr. Eli Haddad, who is the managing director of my clients, and his half-brothers Michael and David agreed that they would separate the rights that they each owned. So BHPC Associates retained the rights in the United States, and all remaining rights, which principally for the purposes of this dispute, UK and EU rights, were assigned to first, in respect of the EU marks, BHPC International, and then by 2009, all of those UK and EU marks had fallen into the ownership of the first claimant, Lifestyle Equities. Now, Lifestyle, the claimant, first claimant at least, has never owned any trademarks in the USA. It doesn't have any business interests in the USA, and other than some aspects of its history, isn't a company that has any dealings that involve the USA. I'll take you through that chronology, for reasons I'm sure you'll be well aware of from reading the judgment and the skeleton arguments, we say that, in principle, the Dutch entity that now owns the UK and EU trademarks is not bound by the consequences of the 1997 decision entered into by a different party.
You draw a distinction between marks which were in existence in 1997
Yes.
and those which came into existence after 1997. We've got a 2004 mark,
Yes.
a 2009 mark, a 2016 mark, and a 2017 mark.
My Lord, yes.
Just explain how they fit into the agreement, if they do.
So, well,
Assume against yourself that your client is bound by the agreement, which relates to those marks which are specified in the agreement.
yes.
If that is decided against you, do you accept that the later marks are within the scope of the agreement, or do you say that they are outside it, irrespective of what the judge found?
So, for the purposes of this appeal, my Lord, and I should preface my submissions to the extent I make any concessions there for the purposes of this appeal and its sufficient conduct. We don't take any point that there's a different approach that needs to be taken with those trademarks.
Either you're bound one way or another,
Yes.
or you're not.
Quite so, my Lord. A factor is that we rely on the earliest of the marks, and so there'd be no point in the UK case carrying on with just some rump of them that's left over. So
we needn't worry about the...
You needn't, no. Just in respect of your Lordship's question, though, the way that the agreement is structured, and you find the agreement in Exhibit 8, sorry, Annex 8, Tab 8 of the supplemental bundle, which is the first exhibit to Mr. Llewellyn's witness statement. The identification of the trademarks is done in a slightly peculiar way. So there are references to marks on page 104 in the second and third recitals. The only marks that are expressly identified there, even though some of the EU marks and the UK mark existed, are the US trademarks that you see in the final line and a bit of the second recital, and then there was a US pending application that's referred to in the first line and a half of the third recital. But in respect of the way in which the agreement for coexistence seems to have operated under that agreement, paragraph 1 over on page 105 deals with a worldwide consent in respect to the Santa Barbara marks, and likewise paragraph 2 deals with a worldwide consent in respect of the BHPC and Beverly Hills Polo Club marks. And I think that it seems that the approach was that it was done by reference to what the logos looked like rather than necessarily any particular registrations.
Oh, I see. So as depicted in exhibit, whatever it is, whether it's 3 or 1 and 2, you say it's just the visual impression given by what is shown.
Quite so. That seems to be the way that agreement was intended to operate. But as I say, for the purposes of this appeal, your lordships and your ladyship don't need to concern yourselves with the difference in the filing dates of those marks. Now, with that preamble about the chronology, there are 3 grounds to this appeal that you'll have seen. The first is in respect of a finding that the judge made that, in fact, the first claimant had become a party to the 1997 agreement because of emails it sent in respect of an application for a trademark in Mexico in 2015. The second ground, which is the most significant, at least the longest to deal with, is in respect of the finding that Lifestyle was bound by the terms of the 1997 agreement by operation of Californian law, even though it was not a party to it. And then the third ground of appeal relates to a finding that even if those 2 first points were wrong, the Californian law of estoppel operated to mean that the claimant was still, not necessarily bound, but unable to deny the effect of the arbitration clause in that 1997 agreement. Now, I'm in the court's hands, but I was going to propose that I dealt with ground 2 first.
Seems to us to be the most important ground.
I agree, so I'll do that. As I just mentioned, this concerns whether Lifestyle is bound by the Californian agreement. Within this ground, there are 3 aspects. The first of those is what law should be applied to consider whether the claimant was bound by the 1997 agreement or not. Secondly, if, contrary to my submissions that I'll make, Californian law is the correct law to apply to that question, what does Californian law provide for? And then the third aspect of this ground, a much shorter one, is whether there's a difference in respect of an arbitration clause rather than other parts of the 1997 agreement that provide for the general consent. Now, in respect of the first aspect, which again, of the 3 is the most significant, in my submission...
Just before you go on with that, what law applies is a question of what? The English law of conflicts, is it?
So, my Lord, in my submission, it appears to have been common ground between the parties that when one's looking at any conflict issue, that it's the English law of conflicts that has to be considered.
So that's a question of English law.
So, in my submission, it is a question of English law. It's a question of English law because the trademarks that were assigned were, well, one was a UK trademark, the others were European trademarks, but no one suggested there was going to be any different law because they were broadly European.
Well, that's a slightly different question.
It is, but one that, in my submission, follows from the same principle.
Yeah.
But my overall submission on this ground, on this aspect of this ground, will be that the correct place to look is the English law of conflicts to determine what the circumstances flow from taking assignment of a UK.
So that's a question of law for us.
My Lord, yes.
If the answer is Californian law,
yes,
we're moving into questions of fact for the judge, aren't we?
That is right, Your Honour, yes. Apologies, that's right, my Lord, yes. His Honour below did address that, and of course that was a question of fact based on the expert evidence.
And for an appeal court,
yes,
looking at a finding of fact,
yes,
albeit of a slightly peculiar kind,
yes,
an appeal court would give more, put it this way, more deference to the first instance judge's findings than it does on a pure question of law.
That must be right, my Lord, yes. Even with that higher hurdle that I have to cross, I on the second aspect of the appeal, say that His Honour got that interpretation of even what the expert said wrong,
right,
and the position that they took, or at least that my learned friend's expert, Mr. Lewison, took, was illogical and wrong and shouldn't have been accepted as the correct approach.
I just wanted to get the framework.
But certainly, your Lordship's absolutely right. It is a finding of fact, so there's a higher hurdle for me to cross to persuade you that that was wrong. In respect of the first aspect of the appeal, what's the law to be applied? The respondent's position before the judge below was that it's the law of the agreement that my client's predecessor has entered into. My position was that it's the law under which the trademarks that were assigned exists and needs to be examined. Now, this was a question, and only a question, of whether the claimant, as a non-party to the 1997 agreement, became bound by it. So it wasn't a question of whether the claimant had become a party to the 1997 agreement. That is addressed in ground 1, which I'll come to. But it was never part of the defendant's application that the claimants were a party. So we're only looking at a situation where a non-party may be bound. And I'd say that that's significant for reasons I'll come to. As you know, the judge held that he should just look at Californian law because that was the law of the 1997 agreement. And he said, by construing the 1997 agreement, I find that the first claimant is bound by its terms, including the arbitration provision. Now,
I'm not sure it's a question of simply of construction, is it? It's a question of Californian law.
Well,
it's the scope of the agreement,
my lord,
rather than its interpretation.
The way that, in my submission, the way that it was approached by Mr. Lewison, the expert for the respondents, and the way that the judge addressed it was only as a question of construction of that agreement. So, and I say that's one of the reasons why I say it was illogical and wrong. The approach should have been, even if Californian law was the applicable system of law to be applied, the approach should have been to say as a precedent, condition precedent essentially, does Californian law mean that the first claimant is bound by this contract, and only then after look to see what obligations it was bound to, which obligations it was bound by. When we come to that ground, with that aspect of this ground, my submission will be that the judge and Mr. Lewison approached him the wrong way. They simply said, well, the agreement says you're bound, and that's the answer. But that, in my submission, leads to a very peculiar consequence that non-parties to an agreement can themselves legislate for an obligation that a non-party to the agreement will.
Well, I follow that. I mean, if this were an agreement governed by English law,
yes,
which said that a third party is bound by this agreement, you might well say, well, as a matter of construction of the agreement, that's what it says, it's quite clear, but it doesn't have any legal effect.
Quite.
So that's why I question whether it's a question of purely of construction
yes.
of the Californian agreement. I mean, as a matter of construction, it's quite clear that it binds all sorts of people.
Absolutely, and yes, I don't suggest that.
The question then is, does Californian law give effect to such a provision?
Quite so, yes. And when we come to that aspect, my lord, the way Mr. Lewison approached it was only to say, I'm dealing with this as a question of construction.
Right.
I construe the agreement, it binds you, that's the answer. So, the first aspect, my lords, my lady, which law applies, I should say as a preamble, I accept that if this was a question about whether a person had become a party to the agreement, that the correct law to apply is the putative law of the contract, or the law of the contract, so Californian law. But when one is considering whether a non-party is bound, that isn't the law to apply, and that's the point I'll develop. I say that that proposition is supported by the authorities, and the first place I take you, if I may, is to the supplement to Dicey in the authorities bundle at tab 8.2. I hope you have 8 subdivided. If you do not, it's page 246.
Blue divisions, that's... Sorry, page which?
246.
Oh, yes. This is Mr. Justice Burton's case, is it?
Precisely, my lord. And it's Mr. Justice Burton's case, the Egazarian one, that I'll take you to in the most detail. In my submission, that case is the one that really determines this issue. But it's summarised here. I have to say, it's not 100% accurate, the summary of it. For brief purposes, just to introduce the point before I take you to the case, it's sufficient. What the extract, or the part of the supplement here says in respect of the applicable law, as it says, the law applicable to the arbitration agreement also governs the question of who is a party to it. That's a proposition I accept. I add, but that law may in turn require reference to another applicable law in order to determine the particular point that arises. And then the example given there was the one that arose in the Egazarian case before Mr. Justice Burton about the consequences of the law of the place where a company is incorporated to whether its parent owes contractual obligations that it entered into. So that's just by way of a broad overview of the proposition that the Egazarian case establishes in my submission. If I could then take you to that decision, it's at tab 3 of the authorities bundle.
Do you accept that it's right for what it decides?
My lord, yes.
Yeah.
Yes. I recognise it's not binding on this court because
No.
it's a decision in the commercial court, but in my submission it is correct what it decides. It may be that my learned friend and I both say it's correct, but we have different views about what it decides. And I think that's possibly largely on what this appeal might turn. But that's, of course, not unusual. I think perhaps the most efficient thing in terms of giving you the background to this decision is to invite you to read from the headnote just after D to the first word on page 208 of the report. So about 2/3 of that first page. So, my lords, my lady, the position was there was an agreement in respect of the development of the hotel. It was an English law agreement, had an arbitration provision. The first respondent had signed that agreement. The second respondent, its owner, another Russian entity, in fact it was the city of Moscow, was said to also be liable to enter into the arbitration because of the consequences of Russian law and how that related to its relationship with its subsidiary. The arbitral tribunal had held that it wasn't liable to be part of that arbitration because under English law it wouldn't have been. And so the claimants, the party alleging that the second respondent was liable to enter the arbitration, sought the court's review of that decision. And then the last three lines set out what the issues were. Issue 2 is the one that I say is relevant here, whether the tribunal had been correct to conclude that Russian law had no effect on whether a non-signatory to English law arbitration agreement could be joined in the arbitration. Now, the situation that you hope have detected from that was that under Russian law, the parent company was liable to join in the arbitration because it was deemed to be jointly and severally liable for all of the contractual obligations that its subsidiary had entered into. The arbitral tribunal, under English law, it wouldn't have been, because that isn't the principle under English law. The arbitral tribunal determined that because English law was the law of the agreement under which the arbitration arose, that English law had to apply and the second respondent wasn't a proper party to the arbitration. If, however, Russian law applied to that question, then it would have been. So, ultimately, the answer that Mr. Justice Burton gave was that the second respondent was liable, and it was liable because Russian law was the correct law to apply. And so, whilst, of course, in that case, the consequence of that was that a party was joined in the arbitration where it otherwise wouldn't have been. It's the proposition of law that I rely on, that one needs to look outside the law of the contract to determine whether the circumstances alleged to make someone liable to join in the arbitration bind it or not. In terms of why Mr. Justice Burton reached that conclusion, my lords, the place to begin, if I may, is halfway through paragraph 12, which is on page 215 of the report, 75 of the authorities bundle.
Yeah.
And it begins there with a record of what the arbitral tribunal had determined in respect of Russian law. So towards the end of the fourth line, their conclusion was, paragraph 478, that Article 105 is legally irrelevant to the construction of the arbitration agreements and forms no proper basis on which the second respondent could be held to be party to an English law contract or arbitration clause. And then there was a suggestion it should sue the second respondent in Russia if it wanted to bind it. Just by way of explanation, Article 105 is Article 105 of the Russian Civil Code, which was the clause that the arbitrators had determined, and on this appeal review decision was accepted to hold that the second respondent was jointly and severally liable for the contractual obligations of its subsidiary. Moving on then to paragraphs 13 and 14, they record the submissions of Mr. Millett, Queen's Counsel, who was the barrister for the respondent to this review decision. So he acted for the Russian companies. His submissions were in paragraph... Perhaps, my lords, my lady, I should just ask you to read paragraph 13, and then I'll make submissions about it.
Yes.
So, second respondent wasn't a party. It wasn't the first respondent necessarily, so it wasn't a signatory to the agreement. Held that under Russian law, the second respondent would have been liable to participate in the arbitration, but the correct thing to do was to apply English law, and so that didn't matter. In paragraph 14, there were three propositions that Mr. Millett relied on in support of that. The first of which is similar to this case, because it was what my learned friend relied upon before His Honour Judge Hacon, was that Rule 64 of Dicey, Morris and Collins, which deals with who is a party to an agreement, was the correct principle to apply. And Mr. Justice Burton considered that the language of that Rule 64 applied also to who was to be a party to an arbitration provision, in essence. The second and third propositions that are recorded in paragraph 14 were, secondly, a reliance on a decision Peterson Farms, in which, on the facts of that case, a group company's doctrine was rejected as being relevant. And then thirdly, just above J, there were conclusions drawn on the basis of the Peterson Farms decision by Mr. Joseph, Queen's Counsel, in his book about jurisdiction and arbitration agreements. Now, for reasons that I will show you, I don't say it's necessary to read those two paragraphs in detail, because Mr. Justice Burton rejected the reliance on those two propositions when he came to his conclusion. And I'll show you the reasons why he rejected them. The things he relied on begin at paragraph 15 through to paragraph 21. What I'll do, if I may, is take you through 16 to 20, but I'll preface them by saying that whilst they largely record the submissions of counsel for the claimants in this decision, Mr. Justice Burton ultimately agreed with those submissions in paragraph 21. So he said that he was entirely satisfied for the reasons set out above by way of answer to Mr. Miller's submissions, that the second respondent was properly joined. So I say that so you know why I'm going to take you in detail through submissions. The reasons because the judge accepted them as correct. So at paragraph 15, there was a proposition that the starting point of the errors made by the arbitrators was to consider the question of who was a party to the agreement rather than considering whether a party was properly to be joined to the arbitration. And that, in my submission, as will become clear through this judgment, is a different matter. Paragraph 16 then just instructs...
So, I mean, in a sense, that goes to the judge's ground one. So
yes.
Even if he's wrong about one, that still doesn't solve the question, because the question is whether your clients can be joined in an arbitration, which the defendants wish to start.
My Lord, yes. It mostly goes to ground two, of course, in the submission, but yes, it's also relevant to that proposition. They've got to be, for one reason or another, joined in the arbitration. That's really the only question that matters, whether they should be joined in the arbitration. Ground one, he answered it in a surprising way, we say.
Yeah.
As I say, 16 just is preface to Mr. Smur QC's submissions on behalf of the claimants in that case. And then 17 sets out a number of matters. First, an acceptance that, again, actually, sorry, rather than me reading out bits of it, it's probably most efficient for me to invite you to read 17.
I mean, we have to remember when reading this judgment that the arbitration agreement with which the judge was concerned in this case was governed by English law. So when he says Mr. Smuhar accepts the proposition that English law governs the question who is part of the arbitration agreement, that is because the arbitration agreement was governed by English law.
That's certainly right, my lord. But there are findings in this judgment which I say are of more general application. Point one. Point two, both parties before His Honour Judge Hacon did rely on English conflicts law in order to say what the approach should be, and the Californian experts did not say, well, there's a different approach under Californian law to looking elsewhere. But yes, so that's correct. But in my submission, for the purposes of this appeal, actually doesn't make a difference. In paragraph 17, you see quite early on, of course, Mr. Smuhar accepts that the question of who is a party to an agreement is to be determined by the proper law of that agreement. But goes on, that is not the question. The question is to be determined is who is bound to be joined to the arbitration. And a number of examples are given of circumstances in which under English law, there'd be many occasions when parties who are not signatories would be either entitled to take advantage of or be bound by the arbitration provision. And those are ones that are not to be determined by the law of the agreement itself. So some examples are given in paragraph 17. You have an indication, at least, sorry, there's a reference just to E. Agency is one example, and of course that would have to be determined by the law that governed the agency agreement. on the line that meets E, whether lifting the corporate veil would be a matter to lead to a non-party to an agreement being bound by it. And that, again, necessarily, in my submission, can't be determined by the law of the agreement in issue. It must be determined by the law that imposes a corporate veil between shareholders and a company or parents and subsidiaries. And there are other scenarios that are identified there. Whilst it says that English law is a necessary starting point, the citing from Lord Justice Mance, as he then was, the question was not who is or was a party to the arbitration agreement, but whether there is a jurisdiction over a non-signatory to the arbitration agreement. And that requires English conflicts rules to address another system of law. And the conclusion then, after the quote from Lord Collins' speech, is that Mr. Smoot emphasised the applicable law, but of course there was a disagreement between him and Mr. Millett as to what the applicable law was. He says it does not, or at least does not simply mean the proper law of the contract. And it's probably obvious, but by saying not simply, because there might be circumstances where the proper law of the contract and the law that the conflicts provisions provides is relevant, coincide. But other cases, that's not going to be the case. Paragraph 18, in paragraph 18, Mr. Justice Burton then discussed further circumstances where a party might be joined by the application of the law other than the proper law of the agreement. Again, my Lord, perhaps I can invite you to read paragraph 18.
This is still recording Mr. Smoot's submissions, isn't it?
It is, my Lord, but as I indicated in paragraph 21,
He accepts them.
he says, yeah, I am, his words are, I'm entirely satisfied for the reasons set out above by way of answer to Mr. Millett's submissions. So whilst they're recorded as submissions, they turn into the judge's findings.
Yeah.
I'm grateful. I think you probably just read to the end of 21. Yeah, I'm grateful for that. I'm sure that's more efficient than me doing it piecemeal. Just to pick up some of the points that you'll have read in that, in those few paragraphs. In paragraph 18, as I mentioned, there's a discussion of some other circumstances. At B on page 217, it was noted that just as the proper law of the contract would not apply to issues of agency, so too it would not apply to whether there's been, as a matter of German law, a merger between an old company and a new one. And again, it seems to me, sorry, my submission, that must be the correct approach. One can't consider whether a potentially merged German company, under a principle that doesn't exist in English law, is a party to an arbitration agreement by only applying English law. And I would add, which is really the focus of all these submissions on this case, that in my submission, the consequence of taking an assignment of a UK trademark or a European trademark has to be determined by the law that governs that trademark rather than the law of the agreement. In respect of paragraph 19, I submit that it's important that there Mr. Smuer was able to, and was accepted to be right to, look at another rule in Dicey to determine which body of law or which principle ought to be applied to whether the Russian parent was going to be bound to this arbitration. I say that's relevant in part because it is a manifestation of what I say is the correct principle, but also in part by analogy with the proposition that I take, which is that another rule in Dicey, in this case Rule 135, is the relevant one to be considered. Paragraph 20 that my Lord's read is the case. Sorry, is the place where first it notes a difference between, again, as has been said before, identifying who is a party to the agreement and who is to be bound by the arbitration. Goes on then to distinguish the Peterson Farms case, in my submission, on the basis that it just wasn't a point in issue in that case. It rejected an idea of a parent company being liable for its subsidiaries. But
neither system of law recognised
exactly
the proposition.
So it's not surprising at all that was
your point's really from J onwards, isn't it?
my Lord, yes. So the on the other hand part,
Yeah.
yes, exactly so. Yeah, and as I say, on the other hand, the issue is whether a non-signatory can be joined because of some other circumstance. My paraphrase of what Mr. Justice Burton found. To consider that the place to look is the law that applied to that circumstance. So in the Egazarian case, whether Russian company law had that consequence, here I say whether taking assignment of a UK or European trademark would have that consequence. At the end of paragraph 20, my Lord, my Lady, the example that Mr. Smuer gives is quite relevant in my submission. So there, of course, he's making essentially an analogy with the invented law of Ruritania. But the example given is that suppose the law of the proper law of the contract was invented unknown Ruritanian law, and under Ruritanian law it was suggested that shareholders were responsible for contractual obligations that a company had entered into, and therefore that English shareholders were to be sued by a counterparty to that Ruritanian agreement under that law. Mr. Smuer's proposition, which the judge accepted, was that it must be right that English law is the correct question to be applied to that, because it's English law that governs the relationship between the shareholders and the English company. Now,
could you just unpack that for me? I mean, on the facts of the case, Russian law said that the parent was liable for the subsidiary.
yes.
Why is that different from Ruritanian law, which says the shareholders are liable with the company?
So, well, because
It looks to be a bit self-contradictory.
well, in my submission, my Lord, no, because they're looking at different parts of the they're considering different parts of the issue. So the issue in the Egazarian case was that the contract was under English law,
Yes.
and it was the local law where the company was incorporated,
Oh, I see.
which was the one to be applied to considering whether the parent was liable for the acts of its subsidiary. In Mr. Smuer's Ruritanian example, it's the opposite.
Governed by Ruritania.
The Ruritanian law governs the agreement, but it's the local English law which has to determine the relationship between shareholders and company. So it's the Ruritanian example is more akin in terms of the fact to the example that I'm suggesting should be taken, should be accurate. It's essentially the other way around. So it illustrates the principle. It's also, in my submission, important because it shows that this isn't a principle that's solely or unique to English law. So it isn't only when there's an English law contract that one has to look at the relevant law to the circumstances said to make someone liable to be joined in the arbitration. Here it's Ruritanian law with all of its unknown consequences. Yet still, the conflicts provisions say that you've got to look at the local law that governs relationship between shareholder and company. Now, that other than noting in paragraph 21 that ultimately Mr. Smuer's submissions became the judge's judgment, which I think your lordship has read, those were the submissions I was going to make on the Egazarian case. My learned friend also relies on two extracts from textbooks. One is Briggs on civil jurisdiction and judgment, and the other is Merkin on arbitration. If I may just take you to those briefly. First is Briggs, Authorities Bundle 7, Authorities Bundle Tab 7, page 155. In my submission, this isn't really a relevant consideration. So you see the sideline part, the paragraph that begins by contrast. Perhaps I'll just invite you to read the paragraph and then I'll make my submissions on it.
This is page 155.
My lady, yes. So that paragraph in my submission is dealing with a very different situation where an insurer is subrogating a claim that the insured may have. That isn't analogous to the situation before this court today in my submission. In a subrogation, the insurer would sue typically in the name of the insured. So it's no surprise that if the insured is subject to an agreement subject to a particular system of laws, that the insurer should also be subject to those if it subrogates that claim. So the short point on Briggs is, in my submission, it's not relevant. The second extract from a textbook is Merkin, which is tab 9 of the Authorities on page 321, the bottom of page 321. So the sidelined part is that the law applicable to the substantive agreement is to be used to determine the identity of the parties to the agreement, which I accept is the correct principle when one's looking to see who the parties are. But it goes on, Merkin goes on, however, the rather different question of whether a third party can be joined to an arbitration has to be resolved. What's then said is under the law of the place of the signatories in corporation and not the law governing the substantive agreements, and then goes on to cite Egazarian. Now, in my submission, that proposition that other than the law of the contract, you look at the law of the incorporation of the signatory, must have been a statement that was based on the particular facts of Egazarian. doesn't matter in my submission. It would matter if the question turned upon factors related to incorporation, of course. But if the issue is something else, then the place in which the signatory is incorporated may not necessarily tell you what the correct law to apply would be.
So your point here is that if your clients are not parties to the agreement,
Yes.
then whether they can be joined in an arbitration depends on the UK/EU law of trademarks
Quite.
and not the Californian law of contract.
My lord, yes. And it's perhaps more than just the UK or EU law of trademarks, but it's the UK or EU law which would determine what the consequences of taking an assignment of a trademark were. I should just say that the end of that section of Merkin goes on just to analyse Egezarin in my submission in the same way as I just have before your lordships and your ladyship. So, my lords, as a consequence of that, my submission is that by taking assignment of the EU and UK trademarks, a Dutch business doesn't become bound to arbitrate in the USA just because an agreement that it knew nothing about could be construed to say that that's the case. And I'll just develop what the correct approach should be, and I'll do that by reference to Dicey Rule 135, because, as I mentioned a moment ago in my submission, that deals with the consequences of what happens when one takes an assignment of an intellectual property case. So you find that, my lords and my lady, it's in tab 8. It's 8.4, but I don't know if you have subdivisions. If not, it's page 294.
Yeah.
So it begins the bottom of 294, assignment of intangible things. Now, the rule has 3 parts, 1A, 1B, and 2. Before I invite you to read it, which I will, 1A in my submission doesn't have a bearing on this issue. It's only relevant because it actually has a definition that's used in the other 2 points. 1A only relates to the mutual obligations as between an assignor or an assignee. It doesn't have an impact on what relationship with a third party to that assignment might be. But if I can invite you to read that rule, I'll then make submissions about it.
We're mostly concerned with sub-rule 2, aren't we?
Yes, my lord. Sub-rule 2 in my submission is the clearest. I also submit that sub-rule 1B has essentially the same impact because it is also a proposition that relates to how counterparties to an assignment, what their relations with a third party, the debtor in the definition here might be. The language of 1B is narrow and 2 is broader, but in my submission they reach the same meaning.
How far do you want us to read this?
Oh, apologies, my lord. I just wanted you to read the rule.
Right.
Sorry, I should have been clearer. In my submission, as I've said, paragraph 1A isn't relevant for these purposes. 1B and 2, in my submission, they amount to the same thing. 1B talks about the law governing the right, in this case, the law governing a trademark, so undoubtedly the law governing a UK trademark is UK law. And 2 talks about the law with which the right assigned has its most significant connection, which again, with a UK trademark, must be the UK law, and similarly with an EU trademark. The only further comment to make about 1B is that the language is narrow. It talks about invocation of rights against a third party, in essence. But in my submission, the principle must cut both ways. So not only does the principle under 1B apply to whether an assignee of a right can enforce an agreement that its predecessor had with a third party, it must also apply as to whether the third party can enforce some right it had with the assignor against the assignee, which is the situation that's argued in this case. And whether it's 1B or 2, in my submission, that it reduces to the same issue, which is that the relevant law to apply is UK law or EU law. Now, for in my submission, that approach entirely makes sense. And I'm going to seek to illustrate it with an example, which is to imagine that rather than this being an assignment of trademarks, intellectual property rights, which are plainly situated in the place where they're registered, imagine that this dispute concerned land. So rather than being a registered trademark, there was a dispute concerned land in England. The land was bought by a Dutch company. Some years after purchase, it found that someone they considered to be a trespasser was now in place on their land. And the perceived trespasser said that they had entered into an agreement with a previous owner under, in my example, Ruritanian law, following Mr. Smoover's lead from Egazarian. And that under Ruritanian law, that agreement gave them the right to occupy that land and some land in Ruritania.
You're maybe on tricky ground here because you're straying into areas of overriding interests, which you may not want to do.
Yeah, so, my lord, overriding interests under English law.
Yes, yes.
So, but this is the proposition.
Your example was somebody in occupation of the land.
Yes. Oh, so well, some years later they find a new person has come onto their land, is what I meant, rather than they'd been there when they bought it. So, apologies. But the person was to say, well, I have a license that allows me to occupy this land in July, let's say, and also some land in Ruritania in July. And they say, under Ruritanian law, it doesn't matter that you never knew about this agreement when you bought the land. And it doesn't matter that it was an agreement with a third party that you weren't privy to. You're still obliged to allow me possession of this land for the whole of July because that's what my Ruritanian law agreement says. And suppose further that it had an arbitration clause in it. And if the landowner then came to the English court and said, I'd like an injunction to make this person leave my land, would the English court say, yes, you can have your injunction under English law, there's a trespasser here? Or would they say, no, you have to go to arbitration in Ruritania because that's what Ruritanian law that governs this agreement says is your obligation? In my submission, that can't be right. It seems in my submission in respect of land, subject to any other particular complexities that might arise in respect of that type of property, it would be a fairly ludicrous proposition in my submission to say that someone not knowing about a foreign law contract was bound to allow trespass on what would otherwise be trespass on their UK situated property.
So if, for example, you take an assignment of a lease which contains an arbitration clause, you would say that's binding on the assignee only because English law says it is.
Yes.
As a matter of English property law.
Yes, and so equally it would be, suppose that you entered into an agreement under Ruritanian law to receive assignment of a lease. You couldn't then say, it could be a great swindle for anyone who wants to get out of a restrictive covenant or so on to say, oh, well, whilst I've entered into a deed that's subject to Ruritanian law, which says I take this land, but Ruritanian law doesn't recognise a restrictive covenant, so I'm not bound by it. That also can't be right. It must be the law that is most relevant to, well, exactly as Dicey 135.2 says, the law with which the right has its most significant connection that must apply to what the consequences are. Now, the approach that my learned friend takes and the judge below takes would be that I'd be wrong about my Ruritanian law example. The English court would say, no, the only law that's relevant here is the Ruritanian law of this contract, and construction of the contract says you're bound by it. But as I say, that's such a startling result that in my submission it must be wrong, and Egazarian indicates why it's wrong. In my submission, further, there's no real distinction between land and intellectual property rights for the circumstances of this case. I cited in my skeleton argument at paragraph 49.1, which is tab 2 of the core bundle, another part of Dicey, Morris and Collins, which is it's also in the authorities bundle, but I cited it by reference to the extract from Peer International and Thermidor, a decision of Mr. Justice Neuberger, as he then was, which was there in respect of copyright, that dealt with what the essence of an intellectual property right was. And I refer you to that just as a short point to say, well, in essence, an intellectual property right is so closely tied to the territory in which it's enforceable and under whose laws it exists that must be the place where any consideration about the effect of taking an assignment of it must be considered. So, my lords, my lady, those are my submissions in respect of the relevant law to be applied. In my submission, it must be the law of the place where the registered trademark is registered.
You're citing from Mr. Justice Neuberger. We've got the Court of Appeal.
You do
in our bundle. Is there anything relevant in that?
I'd cited that for a different proposition that comes later in my skeleton argument, but no, I've referred to it in 49.5.2 of my skeleton argument. 49.5.2 of my skeleton, right. Which was 49.5 was developing a different point that I don't really think can possibly be in dispute, which is that the law under which a trademark is registered is the law with which it has its closest association. And I was developing that by analogy with, as one manifestation of that, one has to look at that law when considering whether an assignment is valid or not. But I should be clear, my proposition doesn't, this isn't a proposition about assignability or not. The assignability point only arises as a support for a proposition that English law is the most closely, UK law is the most closely associated with the UK trademark and so on. Turning then, my lords and my lady, to the judgment, which is in the core bundle at tab 8. The way this issue of the applicable law was addressed is found at paragraphs 42 to 54. So that begins at page 109. Apologies, actually 43 to 54. It's your lordships and your ladyship have read the judgment. I'll take you, if I may, relatively quickly through these paragraphs. So 43 notes the judge is turning to the next point, and correctly identifies a law which determines whether the claimants are bound by the provisions of the agreement. So that's so far so good. And then records what the different propositions were. At 44, he sets out Rule 135 of Dicey, which I took you to a moment ago.
Yeah.
And then 45, he says that, I focused on Clause 2, particularly the possibility that the effect of an assignment of an intangible may be governed by the law with which the right assigned has its most significant connection, and that is my proposition, the effect being whether it was bound by the 97 agreement. Then the judge records a submission that, I say I didn't make. He says Mr. St. Quintin took effect to have a broad meaning so that in the context of the present case it includes construction of the arbitration provision contained in the 97 agreement. That wasn't quite my point. The point was that English law, because that's what applies to the trademark, is the one to determine whether the claimant is bound by the 97 agreement. It isn't an issue about construing that agreement. It's about a preliminary step to that. Does the agreement have any relevance to the claimant or not? So that, in my submission, was an incorrect record and may have had an effect on the judge's approach later. He then recorded 46 to 40 to 50 in essence.
50?
46 to 50, my lords, yes.
Yeah.
My lady. So he recorded
You say 48 is too narrow. What you are saying is that the effect of an assignment of a UK registered trademark is determined by the Trademark Act and English notions of what happens when you transfer a property right from A to B.
Quite so, yes. And the reference to assignments and so on was, as a moment ago said to your lordships and your ladyship, a way of illustrating the close. What is the law with the closest connection? The proposition I was making was different, and in my submission rejected for the wrong reasons. 52 records the judge's rejection. 51 records the rejection of Part 2 of Dicey. 52 records the rejection of Clause 1B, which it's slightly difficult to explain precisely what the judge was addressing in 52. It just says the words, I guess, of the subclause don't stretch to the effect of an arbitration agreement contained in a contract which is not a contract for the assignment of IP rights and a non-signatory to the contract. In my submission, the purpose of reference to 135(1)(b) was to say, exactly as I have to you this morning, that the correct law to apply is the law that governs where the trademark is registered.
I mean, we have to be careful about treating Dicey as if it were a statute.
Quite so, absolutely.
It's a textbook,
yes.
Very well respected,
yes.
But it's a textbook.
Yes, and in my submission it may be the judge who took an overly literal approach to the way that rule was drafted, because 35(1)(b) is from the perspective of whether, I mean, it talks about debtors, because I think that's probably the most commonplace right that might be assigned. Intangible that's assigned is often a debt. But it talks about, because it's focusing on debtors, it talks about whether the assignee can enforce the debt against the third-party debtor. But as I mentioned before, it must cut both ways. It must also apply to whether the third party can enforce rights it had with the assignee or against the assignee. 54, sorry, then in 53, the judge was turning to my own friend's submissions and Rule 64, which is the one that deals with who's a party, as Mr. Justice Burton said it would extend to, but also to the law that applies to the interpretation of that agreement. And at 54, he concluded that that rule was more relevant. And the reason why he said that rule was more relevant in my submission was also an error. So I'll invite you to read 54 and then explain why I say it's an error.
He's conflating two different points there, isn't he?
Yes.
I mean, suppose that the agreement has said this agreement binds the BBC.
Quite.
Well, as a matter of construction, that's clearly what it says. But
yes.
The question is, does it?
Yeah. No, exactly, my lord. That's, I think.
But even if he's wrong about whether it's a question of interpretation or not, he may be right. You say he's not, but he may be right about whether the effect of the agreement is to be determined in accordance with the law chosen by the parties. You say he's wrong. See the Ruritanian example.
Yes.
Given by Mr. Justice Burton.
Quite so. Yes. But certainly, that 54 in my submission, that's really the heart of the judge's error. He was led to it by Mr. Lewison in my submission, the expert for the respondents to this appeal. And I'll show you in a moment why I say that's the case. But it gets the whole analysis the wrong way round. It looks to the agreement to say, does it say it binds you, rather than determining first whether the agreement does bind you. And it must be the latter approach that's correct. So, yes, and the final proposition is on just in respect of that. So the judge went on then to deal with another aspect that doesn't arise in my submission, but doesn't arise on this appeal, certainly. A point to make is that there's never been any suggestion that absent the application of Mr. Llewellyn's view of Californian law, a person who takes an assignment of a UK trademark without knowledge of contractual rights that a predecessor has engaged in is bound by those contractual obligations. And so if I'm right about the correct law to apply, that's the end of the matter in my submission.
Is that because the register is regarded as definitive?
Well, it's not.
Other factors don't come into it.
It's not solely a question of any peculiarity of trademark law and what the register says. It's simply a matter. Well, it's at one level, it's a matter of privity of contract. If I take an assignment of a right from one person, I don't have privity with any contract they may have entered into with a third party. There are some aspects of the Register of Trademarks where rights that are owned by an existing owner to a third party are recorded, and those then bind anyone who takes the right, and that's unsurprising. But it isn't solely as a consequence of that registration element that I say English law
is it really a question of privity of contract? What you are acquiring when you acquire a trademark is a piece of property.
Yes.
Because that's what the Trademark Act tells us.
Yes.
It's personal property.
Correct.
So the question is, what rights burden personal property
Yes.
when the property is assigned, sold by one person to another?
Yeah, and in my submission, there aren't any subject to under trademark legislation whether certain things are registered.
Yeah.
So those are my propositions about the areas the judge fell into. I then turn to the second aspect of this ground, which is what Californian law was. So this is, if I'm wrong about the correct approach to the legal system to be applied to this question, the question is, what impact does Californian law have if it's the relevant set of laws for determination of the obligations that may be owed by the claimant to the respondents. Now, this was addressed in the judgment at paragraph 65 onwards, so that's page 115 of the bundle.
Yeah.
At 65, the judge says, I now turn to the central point of debate. I'm not sure whether it's right to describe it as a central point, but nevertheless, it was an important point. In particular, its effect with regard to the claimants. He then set out the evidence that was relied upon by the parties. Both had expert evidence, and that begins at 66, setting out some of the history about the background of the experts. And then at 68 introduces a summary of Mr. Lewelyn's evidence, which goes from 69 onwards.
71 and 72, which are the important parts here.
My Lord, yes. I mean, in my submission, 69 we can ignore. 70 to 72 are the important aspects. What Mr. Lewelyn first said, this was in his first statement, was that there was, under US federal law, which is accepted as the correct law to apply even in California, because trademarks in the US are items of property that exist under federal legislation. It was Mr. Lewelyn's evidence, which isn't disputed, that if one takes an assignment of a US trademark, then you are bound by any acts that burden that trademark that had been entered into by a previous owner. And that doesn't matter whether you know about that burden or not, or whether you... and in 71 he indicates that coexistence agreements also fall within the types of agreements that will burden a contract. Sorry, burden a trademark in the US. And then the judge records 73 onwards that those propositions were then applied by Mr. Lewelyn to the 1997 agreement. 74 records the response from the appellant's expert, Mr. Sosnicki, and records that he had reservations about three of the latter three of Mr. Lewelyn's principles, so those in 70, 71 and 72. And he indicated that, in his view, US law did not have the same consequence if someone only took an assignment of a non-US trademark.
Well, does he?
So,
He says that Mr. Lewelyn hasn't explained this.
yes.
Doesn't consider whether the Lanham Act would apply, even if it would potentially create a conflict with foreign law.
Yes.
But he doesn't go on to say, and it would, and therefore it doesn't apply. So it's not a very forceful report.
Well, my lord, what Mr. Sosnicki identifies is that Mr. Lewelyn had not identified any case. So he doesn't say this, but had not identified any basis on which to say.
So Lewelyn comes back with his second statement and says, well, now you pointed that out, this is what I say about it.
Yeah.
And Sosnicki doesn't reply to that.
Well, because I can't remember exactly the chronology, but this was an application rather than a period where there was, so it was applicant's evidence respondent to the application's evidence reply. But what's important in my submission is how Mr. Lewison responds to that, because he gives some clarity about what he's saying. And that's really, that's all recorded in paragraph 77 of the judgment. Yes. The originals in the papers as well, but the relevant extra are all here in the judgment, so that's a convenient place, I'm sure, to look at it. He recognises that Mr. Sosnicki has posited that the statement simply assumed that Californian and federal law applied to the dispute, and recognises that Mr. Sosnicki did say that that position was incorrect because the trademarks are registered in jurisdictions outside the USA, but goes on to explain what his approach was. And paragraph 10 in my submission is crucial. So again, I'll invite you to read that. If I can invite you to read to the end of the extract, is in paragraph 77 of the judgment. So, my lords, my lady, paragraph 10 explains Mr. Llewellyn's approach. He says, he says, I do not believe that Californian law applies to the dispute based on the jurisdiction in which the BHPC marks are currently registered. Isn't 100% clear from that sentence what he means by that, but I think he goes on to, and I submit that he goes on to explain what he means in the rest of paragraph 10. Rather, I believe Californian law applies to this dispute in question as a matter of contract. That's because the question is whether the contractual obligation to arbitrate the 1997 agreement binds the claimant. That is a question of construction of the 1997 agreement. And that, in my submission, is the error that he led the judge to reproduce in the judgment, which we saw a moment ago. So, again, has the process the wrong way round. It's just looking at the agreement to see what it says, rather than positing any basis on which the agreement would bind a third party.
What is he? What about for his paragraph 13?
Yes, I
mean, I know he uses the word construction, but that's not really what he's doing.
Well, in my submission, it is what he's doing, because in 13, he is simply saying that he's looking at how an assignee would be treated under Californian law. An assignee of a Californian US trademark would be treated. He isn't saying, well, the opening part of paragraph 10, I think, makes this relatively clear. He's not saying that Californian law says that the assignee of any trademark anywhere in the world is bound by another agreement that a previous owner of that other trademark had entered into. And I've paused to note that would be quite an extraordinary aspect of Californian law if it was true. He relies on it solely because he's saying, well, I'm looking at this purely from the perspective of Californian law because that's the law of the contract. I'm dealing with this only as a question of construction. When in the Californian court, I see that someone has taken assignment of a trademark, if I was in California, I would say they were bound by any previous agreement that bound that trademark. He certainly doesn't say, and the case he cites was a case about the assignment of a US trademark. He doesn't say that there's a case or a textbook or an article that suggests that Californian law says recipients of non-US trademarks are to be bound by obligations of their predecessors. In my submission, all he's doing is saying, well, the 1997 agreement means, within the very narrow focus of Californian law, certain things. And, my lord, that's made more clear, I think, in my submission, in the second part of paragraph 14. So,
Yeah.
The opening sentence of 14 is a criticism of Mr. Sosnicki for saying, well, it's a slightly odd way round to do it in my submission, but it's a criticism nonetheless to say, well, despite the fact that I didn't put forward an authority that says non-US assignees or assignees of non-US trademarks are bound in a particular way, you haven't put in an authority to say that's wrong. And he goes on then, in fact, so within the same paragraph, it must be meant to have been support for his proposition that Mr. Sosnicki was in error in not proposing a reason why the Californian court would reach a different conclusion. He focuses only on what the 1997 agreement says. So, he looks at clauses of the 1997 agreement, which, as your lordship has said, undoubtedly do say that the agreement applies to the assignees of BHPC Associates, who's the counterparty with the respondents. He doesn't say there's any other principle of law, federal or Californian, which says you'd be bound. He focuses solely on what the agreement says. And that, in my submission, is, it's entirely consistent with the approach he said he was going to take in 10. And in my submission, it illustrates that when in 13 he made a reference to how Californian law applies, and I say in brackets, to the assignment of US trademarks, he was dealing with that still only as a question of construction of the 97 agreement.
But isn't paragraph 11, it may appear after 10I, obviously, but is it necessarily circular to say the agreement is governed by Californian law? And he's talking about the arbitration agreement here.
Well, yes, he's talking about the whole of the agreement that contains the arbitration clause. Yes, it is governed by Californian law. And I don't...
And your expert didn't disagree with that, did he?
Didn't agree that it was covered by Californian
He didn't disagree because he agreed the first principle, didn't he?
Yes. Well, the first principle was that the respondents who were signatories to that agreement were entitled to rely on it for whatever it said. But, my lady, again, in paragraph 11...
Well, he identified certain of the signatories who he said could
Yes.
enforce the clause.
Yes.
Presumably against the claimants.
Well, he didn't say... So in Mr. Sosnicki's... in Mr. Llewellyn's first witness statement, where he set out those propositions that were recorded in the judgment at 69 and 70 onwards. 69, Mr. Llewellyn's first proposition, is that the 8th defendant can enforce the arbitration provision as a signatory. He didn't say he can enforce it against any one party to the agreement or not. It was simply a proposition that...
Well, how else would he enforce it? He's got to enforce it against somebody. So Mr. Llewellyn's first proposition is that the 8th defendant can enforce the arbitration provision
Yes.
as a signatory. The 3rd and 4th defendants can also enforce the provision under their status as third-party beneficiaries pursuant to Clause 12 of the 1997 agreement. And your expert agreed with that proposition.
With the proposition that those entities, if they were entitled to rely upon that agreement, they didn't. So my expert didn't agree. Well, there wasn't a proposition made. My expert didn't agree that it meant they could be enforced because they were signatories against anybody.
You're saying that just was simply dealing on one side of the
Quite so.
question. Who can enforce and why? Because it's different as between the 8th defendant and the 3rd and 4th defendants. but it doesn't say anything about who they can enforce against. It's
That's-
just dealing with their status.
Yeah, my lord, yes.
And your expert accepted that point.
Yes.
Sorry, not status, ability to enforce either as a signatory or as third-party beneficiaries, because there was a question about whether they came within the scope of those entitled to the benefit, but said nothing about the burden. That's your point.
That's exactly right, my lord. Yes, that's my position. And so it's the part that's summarised in 69 of the judgment is paragraphs 22 to 28 of Mr. Llewellyn's first witness statement. But that's a fair, in my submission, that's a fair analysis of what it says.
What's the reference to the
Supplemental bundle, tab 7, page 96.
And where does your expert deal with it?
So his report is tab 14, and in respect of I don't believe he says anything about that section.
So just to be clear, in supplementary bundle, page 96 and 97,
Yes.
those paragraphs, is this right, are all under the heading application of the 1997 agreement to the defendants
Yes.
under Californian law.
Correct.
And then the next section talks about application of the 1997 agreements to the claimants under
Yes.
Californian law. So you say the summary in paragraph 69 of the judgment is plainly just dealing with one side. It's paragraphs 22 through to 26 of that report.
My lord, yes, exactly so.
Sorry, yeah, right, okay, got it.
And then I don't believe that Mr. Sosnicki took issue with those matters in the report that he had issues with those paragraphs. He didn't. It wasn't in dispute that the eighth and the eighth and third and fourth defendants, respondents now could take advantage of that provision. He begins his criticism in respect of later paragraphs. Yes, again, overall in paragraph 11, as with 10 and 14 in my submission, Mr. Llewellyn is still approaching the question solely from the perspective of construction of that agreement rather than any other basis which says the claimant should be bound by that agreement. Finally, in the passage I asked you to read at 15, there was a criticism of Mr. Sosnicki for not having identified the possibility of conflict between Californian law and UK and EU trademark law. But that conflict was the apparent difference in approach to whether assignees of rights would be treated as bound by obligations owed by the assignor.
Yeah.
That's the difference. In paragraph, just to finish what how the judgment dealt with this issue, 78 of the judgment notes that concludes that Mr. Llewellyn had rowed back from his reliance on the Lanham Act, which I'd say was a correct assessment. The point he makes, as the judge understood him, was that the question of whether any burden attached to the trademarks which are subject to the 1997 agreement, and if so, which burdens required the application of Californian law to the law of contract to the 1997 agreement.
As I read these paragraphs, paragraph 78 picks up what Mr. Llewellyn had said in his paragraph 11 on the preceding page.
Yes.
And paragraph 79 picks up what he had said in his paragraph 13 on the preceding page. Those are the 2 points that the judge is making.
I think 78 picks up what he said in paragraph 10 of the preceding page. The need for construction, well, perhaps the end of 10 and 11.
It talks about requiring the application of the Californian law of contract, the 1997 agreement, and that's the question that he addresses in paragraph 11, how California law will be applied to a dispute between claimants and respondents. I think that's where it comes from.
Yes. Introduced in the context of it being a matter of construction. And yes, in paragraph 79. So paragraph 79 repeats his view as a matter of contract law that the assignee of trademarks would take the burdens. The next sentence, he said that Californian law does not discriminate in this regard between US and non-US trademarks. Well, in my submission, Mr. Lewison didn't say that Californian law does not discriminate. What he said in 14 was that the 1997 agreement didn't discriminate, which is a different point and one that certainly doesn't have the same consequences in my submission. In my submission, what the approach that was taken by Mr. Lewison and then taken by the judge, as I've said more than once already, was illogical and approached the question from the wrong starting point. It didn't address why, and having established a reason why, if the claimant was to be bound by this agreement, it simply looked at what the agreement said, found that it extended to the claimant, and then considered that as being the answer to the issue. The final aspect of the judgment on this point dealt with a case that Mr. Sosnicki had cited, 80 to 84, a case called Ubiquity, which you see there. That was a case that's essentially summarised in the extract at the top of page 122, which is in paragraph 82 of the judgment. And it was the judge was right to say that it wasn't entirely on point. Sorry, I'll pause for you to read it. And the point that Mr. Sosnicki was seeking to support by citation of that case was that the US, under US law, there was a resistance to making decisions that would have an effect in another territory. And if that's right, then it would be strange that Californian law, without any judgment that says this, or textbook that says this, or article that says this, would hold that an assignee only of a non-US trademark would be treated in exactly the same way as an assignee of a US trademark. So it was a point, as the judge said, not exactly that addressed that issue of US versus non-US trademark assignments, but which when looked at overall, was an indicator that US law would be unlikely to have a proposition that merely taking assignment of a non-US trademark was to be treated in exactly the same way. Finally, paragraph 85 is the judge's final conclusion on this point. California law of contract would be applied to the 1997 agreement to determine the effect of the arbitration provision. I accept his evidence under California law. It makes no difference to the effect of the 1997 agreement, including the effect of the arbitration provision as to whether the trademarks protected are US or non-US marks. So for the reasons I've given before in my submission, that shows the judge was only approaching this as a question of construction, not as a preliminary question of why the claimant should be bound. So that's the second aspect of ground 2. The third aspect of ground 2 was whether there should be a different approach to a burden to arbitrate. I'll deal with this, I hope I can deal with this quite quickly, because whilst it's a relatively long, a few pages of judgment that set out Mr. Sosnicki's evidence at 86, at 87 the judge concluded that, or held that there did not seem to be a dispute between the experts, that, as Mr. Sosnicki had said, absent a clear agreement to arbitrate, Californian courts will not infer the right to jury trial had been waived. And goes on to record the point at issue is whether taking assignment of a trademark protected by a contract can qualify as a clear agreement to arbitrate on behalf of the assignee. Now, the judge then went through an analysis of a number of cases that were cited by both experts, the two cases that were cited by both experts, one Mag Instrument and the other one Russell Road, and ultimately concluded at 93 that found that those cases established that the general proposition was a burden attaching to a trademark, and I insert a US trademark because that's all that was an issue in, that's all that was assigned in those cases, which is subject to a settlement or coexistence agreement passes with its assignment. I accept it makes no difference. He says it's true that neither Russell Road nor Mag Instrument was about an obligation to arbitrate, and Mr. Sosnicki did not. He says Mr. Sosnicki did not explain why that would make an exception to that general rule, and on that basis he rejected the proposition that there may be any different approach to a burden to arbitrate. Now, in my submission, Mr. Sosnicki had provided an explanation, and that was the thing the judge accepted in paragraph 87. Which was that that absent a clear agreement to arbitrate, Californian courts would not infer the right to a jury trial had been waived. And then even in paragraph 87, or later in paragraph 87, the judge recorded the point at issue was whether taking assignment of a trademark protected by a contract containing an arbitration clause can qualify as a clear agreement. And my short point on this is that the judge was wrong to reject the submission that the need for a clear agreement is not satisfied by merely taking assignment of a trademark without knowledge of a preceding contract entered into by an earlier owner. So for that third aspect, short aspect of ground 2, in my submission, the judge was also wrong to hold that the claimant was bound by the arbitration provision in the 97 agreement.
Yeah.
So, my lords, those are my submissions on ground 2 of the appeal. I should have asked at the beginning of the day whether there was any intention to have a break for the shorthand writers. I know I've gone well over the halfway through the morning.
Straight on.
No, I'm grateful. I can move on. I think probably it's sensible next for me to deal with the estoppel point, which is ground 3. This is the shortest of the 3. So the judge dealt with this from paragraph 104 of the judgment. That's page 135 of the core bundle. And I should say the assessment of the estoppel point doesn't begin there. It begins at 97, but 104 is, in my submission, the first place that one needs to go for the purposes of this appeal. If I could invite you to read 104 to 107.
Yeah.
I'll then make my submissions. So, my lords, my lady, paragraph 104 addresses the judge's conclusions about what the test might be. At the top of page 136 of the bundle, he notes, it was not in dispute between the experts that, as Mr. Sosnicki said in paragraph 30, the equitable doctrine applies only where the plaintiff's claims are dependent upon or are inextricably intertwined with the obligations imposed by the contract containing the arbitration clause. 105, he deals with the fact that the cases he was showing didn't have any additional guidance upon what inextricably intertwined meant. Then at 106, he records he'd set out earlier facts relating to the Mexican Trademark Office application. The claimants represented the office, they were parties to 1997. I found that to be the case. And then, importantly, the question is whether the claimant's claims of trademark infringement and passing off in the present case are dependent upon or inextricably intertwined with the obligations imposed by the 97 agreement. And his conclusion was that they were likely to depend on the protection afforded. Now, in my submission, the question of estoppel, whether it arises or whether it's relevant or not in this appeal, is probably pretty binary and stands or falls with ground 2 anyway.
The problem with 107 is it assumes that your clients can take advantage of the agreement, whereas the point is that absent the estoppel, they can't.
Yeah, well, so it assumes that they are some way bound by that agreement, and that's the only basis on which the judge held that they were stopped from arguing.
And if they are bound by it, then estoppel doesn't add anything.
Yeah, they're bound, so they're going to have to arbitrate. And if they're not bound,
starting point for an estoppel is they're not bound.
Yes, but yet they've in some way
not contractually bound.
Yes, but in some way they've, under Californian law, they have asserted a claim that is dependent upon or inextricably intertwined with that agreement. Yeah. So I think it's in fact only a very short point, which is the only way the judge approached it. Doesn't arise because the 1997 agreement isn't something they're bound by. And if they are, we don't even get here. Even if wrong on that, then in my submission the judge approached it in the wrong way. He didn't apply the test that he'd recorded at 104 because it's not, his conclusion is very brief in 107. It doesn't have a whole, it doesn't have much reasoning. The only reasoning that's given is that the claims are likely to depend upon the protection afforded to the first claimant's trademarks and goodwill by the 1997 agreement. But that can't be right unless he means the success of the claimant's claims, because the claims themselves depend upon ownership of a registered trademark and the acts that the defendants have undertaken.
Well, suppose you plead, let us suppose, I haven't looked at the pleadings, but as you say, where we own this trademark,
yes.
You are using a sign which is confusingly similar to our mark, and whatever consequences flow from that. Are the defendants entitled to say, we've got this agreement, which is coexistence agreement, which says we can use the Santa Barbara mark?
So absolutely, they're entitled to say that in their defence. But that's their defence. It wouldn't stop
my client.
But that's
because what? Because it binds you in some way?
That would be their allegation. Their allegation.
No, all right. Well, but I mean.
Yeah. So sorry, I'm not suggesting.
I don't mean. Are they entitled to plead it? Of course, they're entitled to plead it. Yeah. But do you say that they're not entitled to rely on it as against you because it's not been registered somewhere?
Yeah, it does. It has no
so
impact on
you
my
say
clients.
your rights are just governed by the ordinary law of trademarks applicable to your marks, and this agreement is neither here nor there.
Exactly so.
Doesn't bind you.
Yeah. So it may arise as a feature of a defence.
Or it may go to flagrancy of damages or something.
Perhaps so. Well, perhaps, but
honest belief.
Yes, something of that. Yeah, something of that nature. Yeah.
You say to use the wording of some of the other American authorities. I mean, your allegations are not founded in any way upon any provision of the 1997 agreement.
Precisely so.
And
those other authorities that were cited by Mr. Lewison and Mr. Sosnicki are all ones where the party, they're all kind of quite peculiar circumstances, and not surprising that an estoppel arose. A party is saying, I want to rely on this bit of the agreement, but I don't like this other bit of the agreement. And unsurprisingly, in those circumstances, the court says you can't do that. But here, the claimant doesn't rely on the 97 agreement at all. It says it's irrelevant. And as a consequence, it is not, the claimant's claim does not depend upon that agreement, nor is it inextricably intertwined with it.
I mean, there's a sense that your client, at some point in the past, in a different context, had sought to derive a benefit from the 97 agreement.
So, yes.
Does that fall within
So that was...
any of the US authorities?
I say no. That was the basis on which the estoppel argument was run before the judge. It wasn't said that because the 1997 agreement binds you, you're estopped. It said you did this thing in Mexico 5 years ago, and because of that, you are now estopped. But in my submission, that was an inappropriate, that was wrong, because the test is whether the plaintiff's claims depend upon or are inextricably intertwined with that agreement. They don't depend upon something it may have done in another context at a different time. Yeah. So, in my submission, the judge's finding that the claimants were going to be estopped was wrong on the basis that he found it to be in play. Also was wrong for the basis that the respondents argued below, and there's no respondent's notice, so that alternative basis doesn't even arise today. So those are my submissions on ground 3. Finally, an out of sequence, if I turn to ground 1. Ground 1, it depends upon is an appeal against the judge's findings that were made at the beginning of the judgment, or first part of the judgment, in which the judge held that the claimant had become a party to the 1997 agreement. Now, there are, again, several aspects to this ground of appeal. The first being that this was not a point that was raised by the respondents or, in my submission, raised at the hearing. It was something that appeared fully formed and for the first time in the judgment. And that is an inappropriate thing to have occurred. It isn't a proper exercise of the court's role. The court's role being to determine the arguments that the parties before it ask it to determine. Taking you to the judgment, my lords, my lady, if I start at paragraph 22, which is on page 105, that gives some of the preamble to the judge's findings on this issue. Mm-hmm. He begins, His Honour began, the overall issue is whether the arbitration provision contained in clause 7 can be enforced. There were then some propositions about the 1996 Act from 23 onwards. I don't think I need to trouble you.
We start this point at paragraph 33, don't we?
Right, my lord, indeed. So at 33, there's a suggestion that I contended that English law must be applied to a question of whether a person is party to an arbitration agreement. Now, that may just have been a paraphrase of the submission, but it was not my proposition that there was an issue about whether the claimant was a party or not, because that had never been raised. The issue was whether, as a non-party, it was bound by the arbitration agreement, and that was something I said should be determined under English law for the reasons I've explained in respect of ground 2. I accept that, as I have already in respect of ground 2, I accept that when one's considering who is a party to the agreement, that has to be determined under the law of the agreement. So that's a California law question. So I didn't contend that English law was a question, applied to who should be a party. The judge then went on to record the communications that he had been shown. So from paragraph 34 refers to a letter from 2013, which was around the first time Mr. Haddad's evidence was at some trade show.
Yeah.
He'd been told by someone from Santa Barbara that there was a historic agreement, and so his lawyers at that stage were writing to ask about it. 35, they received a copy of it in 2014. Then 2015, which is the set of circumstances that are really an issue, there was communication with the Mexican Trademark Office because the claimant was seeking the registration of the trademark in Mexico, and as I understand it, the Mexican trademark authorities proactively took objection on behalf of the Santa Barbara mark, or because of the existence of the Santa Barbara mark. So unlike the UK proceedings where another rights holder has to themselves assert that their mark prevents a later registration, the Mexican trademark authorities will do that unilaterally. One way around that was for the Santa Barbara parties to consent to the registration of my client's trademark in Mexico, and that's what was sought. The judge ultimately, so having gone through what happened in the correspondence, the email in 36 of the 9th of June, which is from Mr. Haddad's son, Daniel Haddad, to Mr. Wesley Rue, who I believe is a trustee of at least one of the respondent entities, was a request that the consent letter was signed in accordance with the coexistence agreement that had been brought to the claimant's attention. Then a consent letter was provided, and then the consent letter was, the judge records at 39 that it had added to it some language by the Santa Barbara parties, and he then rejects some evidence at 40 that when that letter was provided to the Mexican authorities, it was done so with that language left in because there wasn't sufficient time to be able to remove the language. Now, I say in respect of that it may be that the judge believed that the only task to be done was just simply to open the Word document and delete the language, but my client's position is, of course, it can't do that. It can't take a signed document from someone and delete bits it doesn't like and then submit that to a foreign registration authority. The time necessary would have been to go back to the Santa Barbara parties and say, look, we don't want to submit a document with this statement in it. But the judge at 41 also notes that there was reference to a coexistence agreement executed between Santa Barbara and Lifestyle, and attached was the 97 agreement. And it was the judge's finding in 42 that the claimant said expressly that this was an agreement between SBPC and the first claimant, and that as a consequence of that, he held that they had, by that exchange of correspondence in June 2015, become a party to the 97 agreement.
Which law is he applying here?
Well, he says, I think he must be seeking to apply English law, because that's how
Why would English law apply?
I don't know, my lord. I say it doesn't.
As I understand it, the point is that since nobody was raising this point,
Yeah.
Nobody had got any expert evidence on US law, which prima facie would be the applicable law.
Quite.
So what the judge said in paragraph
30.
having misconstrued, you say, your submissions,
Yes.
said in 33, even if, as you contended, brackets, you say you didn't, English law must be applied. He then, as it were, went on to apply English law as he saw it.
Yes.
Because he had nothing else to apply.
Quite so.
And
Yes.
the principle of English law he's applying is what? Novation?
Doesn't say. It doesn't seem to be. Well, it doesn't say. I don't know. I don't think it could be novation, because that would, well...
How do you become party to somebody else's contract without a novation?
Well, then I assume that perhaps he thought there was a new offer and acceptance. But he doesn't say that in the judgment.
But the other original parties weren't involved.
Well, exactly so, which is why I say a novation seems to not be the correct answer. And certainly, I'm sure, you know, if it was a
Well, if it was a new offer and acceptance, there'd be two agreements running side by side.
Exactly so, yes. So it'd have to be a new agreement formed in June 2015, not a 97 agreement. So the whole, it's again very briefly reasoned, and the whole passage in the judgment is quite difficult to follow. Just in respect of whether the point was raised at all. Obviously, so my learned friend accepts in her skeleton argument at paragraph 80 that it wasn't raised before the hearing, but it's proposed, she submits in the skeleton argument that it was raised at the hearing, and a number of references are given to the transcript, and that is in the supplemental bundle at tab 5. And there are a few places that are referred to in my learned friend's skeleton argument. The first of which is, it's page 59 of the transcript, so it appears on page 60 of the supplemental bundle. And it begins on line 2 of page 59. So actually, sorry, I should show you just the end of page 58 of the transcript, because that flags the point in the submissions of the application when this arose. So my learned friend was indicating lines 20 to 25 that she was just coming to the end of her submissions about Californian law. Again, can I invite you, my lords, my lady, to read to line 13 on page 61?
On page 59.
So from the top of 59 to 13 on 61, please. So at the end of my learned friend's submissions on the issues of Californian law, the judge raised, well, a possibility that the English doctrine of approbate and reprobate may have some bearing on some issues in the case. He indicated at 12 on 59, he was raising that so that I knew that that was something that was going through his mind. There was then some discussion about where, if anywhere, that doctrine might have some relevance to this case, and what was raised was an issue about the residual discretion to stay the proceedings. So if it wasn't stayed under Section 9 of the Arbitration Act, whether it would be stayed as a case management decision, essentially. And that residual discretion it was potentially in play if one or more of the defendants weren't entitled to stay under the Arbitration Act. In fact, it was never the claimant's position that there should be a division between the defendants and we're proceeding in some of them. It was all or nothing. But importantly, at page 61, lines 3 to 13, the judge explained what the limited extent to which he thought that doctrine might have any application.
Yes.
If it applies at all, it seems to me it only applies to the residual discretion. So as a consequence of that exchange, and no point about the residual discretion being taken, it seemed the point didn't have any relevance. Now, the only place in my submissions to the judge that my learned friend suggests there was a discussion about this issue comes on page 132 of the transcript, page 78 of the bundle. And it's a very short passage from lines 18 to 23, where I was showing the judge one of the emails that had passed between Daniel Haddad and Mr. Rue of the respondents. And the exchange was, the judge said, Mr. Haddad, is suggesting that Lifestyle ratifies the 1997 agreement. My response, yes, that never happened. The judge's response, I see. So in my submission, that didn't at all raise the issue of whether the claimants had become party to that 1997 agreement. And then finally, my learned friend relies on transcript page 149, which is page 83 of the transcript.
This is now her reply.
Indeed. So it's at the end of my learned friend's reply. And from...
Sorry, could you give me that reference again?
Apologies. It's page 149 of the transcript, page 83 of the bundle.
Yep, thank you.
So the relevant, perhaps again, if I can ask you to read from line 3 on page 149, which begins with a different issue, to line 15 on 150.
The judge seems to close that down.
So, yes, so the judge certainly closes down the first proposition, which was, I think, a new point about a UK estoppel potentially applying. Says you can't raise that in reply. Rightly so, I say. Then at line 20 on 149, says, again, I did raise with you both, I think. I say actually didn't raise with me, say, for noting when discussing things with my learned friend, to say that he was mentioning the doctrine so that I knew that it was going through his mind. A doctrine that you can't approbate and reprobate, asked my learned friend how that might apply. Her proposition was that it could be a fallback position, and then lines 9 to 14 was an explanation of what the fallback position might have been. And I think probably the closest that it might be said anyone got to suggesting that there could be a finding that there was an agreement between the claimant and the Santa Barbara parties is my learned friend's submission that line 13 to 14, Your Honour could look at that and could employ that to say there is an arbitration agreement. But in my submission, one, that arose only in my learned friend's reply, and the judge was correct a moment previously to say that no, it's wrong to raise things in reply for the first time.
Yeah.
Secondly, it's not even clear what that submission went to. So, the question of whether there's an arbitration agreement, it wasn't suggested an agreement between the claimants and the Santa Barbara parties, just an arbitration agreement, presumably one that may bind the claimant. But that, in my submission, simply wasn't a point raised before or at the hearing. It appeared only in the judgment. I've already taken you, so there are three final points, my lords. One is I've already taken you through the judgment to show you what the judge found. I say he was wrong to apply English law, and as your lordships, my lady, has pointed out, it's not clear what principles of law he was applying in any event, so it was wrong for that reason. If the point had been raised, then certainly the claimant would have wanted to put in evidence about Californian law and how it bore on this issue. And it's notable that the defendants' Californian experts did not suggest that there was an agreement, and on the contrary, sought to argue that those same emails gave rise to an estoppel. So it seems, if I make the submission, it follows from that that the defendant's Californian expert did not think that exchange of emails had led to an agreement. And then there's a point finally which I will concede. I'd said in my skeleton argument that the judge may have got the relevant standard wrong. I accept that the standard is balance of probabilities, but that there's caution as to whether issues which may turn on evidence should be determined on the papers, and the judge should not have determined this issue on the papers, certainly not without it having been raised by one of the parties. So, my lords, I'll check there's nothing further. So, unless I can assist you further, my lords, those are my submissions on the appeal, my lady.
Thank you very much, Mrs.
Great.
Yes, Miss Lane.
My lords, my lady, I'll just rearrange myself a bit if that's okay. My lord, my lady, we say that this appeal is straightforward and that the judge arrived at the correct answer by a number of routes. I'm going to go through each of those in turn, but we only need to succeed on one of those routes. And our primary route at first instance and in this appeal is as follows. There is an arbitration agreement. It's subject to California law, and the claimants are bound by the arbitration agreement under the California law of contract. And so essentially we say that it's a contractual matter to be resolved by the law of contract, and in this case clearly the law of contract that is applicable is California law. Now, my learned friend has suggested that the result was surprising because he says it's surprising that a non-party that doesn't know about the arbitration agreement should be bound by that. But the fact of the matter is that that is the position under California law, and it applies both because of the terms of the agreement itself, which specifically was said to apply to assignees, successors, etc. And also because that is the operation of California law under which the burden passes with the assignment of the trademark. And just stepping back a moment...
And you need both, don't you? You need both bits of that.
Yes, certainly my, the evidence from my California law expert was that the reason that the burden of the arbitration agreement passed was both because the burden passes with an assignment of trademark under California law, and also because by clause 12 of the agreement that my learned friend hasn't taken my lords and my lady to, but I will, the agreement was to be binding on successors in title. And taking a step back and looking at the commercial reality here, what we had is parties in California who had a trademark dispute with these two trademarks, Santa Barbara Polo Club and Beverly Hills Polo Club, with the polo player wielding the mallet. They had fallen into a dispute about those rights, and therefore they decided very sensibly to enter into a coexistence agreement. Very sensibly, the coexistence agreement applied worldwide to all the rights across the world, and very sensibly it was subject to a single law, the law of California, because my lords and my lady will appreciate that it is not unusual or surprising, as my learned friend seeks to suggest, that when you deal with intellectual property rights in agreements and worldwide intellectual property rights, the parties will have one law governing the agreement. They're not going to decide between them that it's sensible that UK law should apply to the UK rights, that Japanese law should apply to the Japanese rights, etc. That would lead to litigation all around the world, and it would not be a sensible approach. So they decided that California law should apply. They also sensibly decided that there should be an arbitration clause, and that the seat of the arbitration was in Los Angeles, California, and also sensibly in my submission that the agreement should be binding on successors in title, so that it continued to apply even if the rights were assigned away. So that's my sort of overview, and just adding to that, to say that in my submission, my learned friend's approach looks at the question through completely the wrong end of the telescope, if I can put it that way, because he looks at this as all being about trademark enforcement and his client's attempt at enforcing the UK and EU rights. And so he starts with the trademarks and says, well, that's the law that you've got to apply. But in my submission, the question here was all about whether the judge should grant a stay under the Arbitration Act and whether there was an arbitration agreement between the parties. And that is a matter of the law of contract. And that essentially it is why we say California law applies.
So in essence, you say, well, he may or may not be right about trademark infringement. The question is, who's going to decide that?
Yes, indeed, indeed. And when it comes to Dicey and the route that my learned friend wants to take through this, in my submission, my learned friend has glossed over some rather important points under Rule 135. But I'll come to that shortly. So we say the starting point's the 1997 agreement. I will turn that up briefly because I know my lords and my lady have looked at it already. But just to whiz through the clauses that I say are of particular relevance. That's in the supplementary bundle, tab 8.
Yep.
And we don't need to look at the recitals. I think we can start with clauses 1 and 2, which my learned friend has already mentioned. You'll see, in fact, actually on page 105, just above clause 1, that this dispute that was being settled had arisen in Japan, in fact, or one of the disputes that had arisen. And so what happens in clauses 1 and 2 is, on the one hand, the Beverly Hills Polo Club consents to use by Santa Barbara Polo Club of the Santa Barbara Polo Club names and marks, and that is worldwide, importantly. And they also agree that those rights, the marks can be registered in all countries in the world. And then you've got a mirror provision in clause 2, whereby the Santa Barbara Polo Club consents to the use of by the Beverly Hills Polo Club of that name, again worldwide, and consents to registration of marks worldwide. And then clause 7, the parties agree that the agreement shall remain in force and should be irrevocable as long as at least one party continues to use any of its above described marks or trade names. And then if you carry on over the page to 107, the second full paragraph, any controversy, dispute or claim with regard to arising out of or relating to this agreement, including but not limited to its scope or meaning, breach or the existence of a curable breach, shall be resolved by arbitration in Los Angeles, California, etc. And so that's the deal, as it were. We're going to have any disputes resolved by arbitration in California. And over the page at 108, the agreement shall be construed and governed in accordance with the applicable laws of the state of California, without reference to its conflicts of law provisions. And then clause 12 on the same page, underlined, this agreement shall be binding upon and inure to the benefit of the parties hereto and their subsidiaries, representatives, heirs, administrators, successors, assigns, licensees. I probably don't need to read the whole lot out, but they wanted everyone in sight to be bound, I think it's fair to say. And that was, therefore, the agreement between the parties. And the question, obviously, before the learned judge at first instance is, are the claimants bound by the arbitration agreement within this 1997 agreement? And we say that is a contractual issue. And so the law of the contract applies, i.e. The law set out in clause 9, which is California law. And in answer to that, the claimants say, oh no, because we're relying on a UK and EU marks, English law must apply. despite the fact that they're a Dutch company and they've taken assignments of this trademark under who knows what law, because what my learned friend didn't do at first instance was put in evidence the assignments, as my lords and my lady will appreciate. There was a chain of assignments which started off, and I can come to those in a minute, with an assignment from a US entity to another US entity. And I think all the way through the entities are US entities and finally end up with a Dutch entity. So we say that the judge's reasoning on this point is clear and correct. And my learned friend's obviously taken my lords and my lady to it already, so I will do so more briefly. But it was essentially addressed by the learned judge by reference to the rules in Dicey, and I absolutely accept what my lord says, that Dicey isn't a statute, and obviously one needs to sense check the propositions, but that was the way the case was argued in front of the learned judge, and his reasoning is set out in the judgment between paragraphs 43 and 54, and what the judge does is set out in overview, is set out the two rules, and he explains why Rule 135 does not apply, and why Rule 64 does apply. And I actually want to start with the latter part of his judgment as to why Rule 64 does apply, and that's set out at paragraphs 53 to 54.
Yeah.
And I'll expand on this a little by taking my lords and my lady to Dicey itself. And so at paragraph 53 we have the relevant rule, and in fact it might be helpful to turn up the authorities bundle at the same time and actually look at it in context. And so that's that's tab 8 of the authorities bundle, chapter 16, which is, in my bundle it's tab 8A.
I'm not sure I've got these tabs. I've got little blue bits of paper, but they're very difficult to find anyway. It's page 160.
It's page 160, exactly. And the heading is Arbitration and Foreign Awards. And so we have Rule 64.1, the material validity, scope and interpretation of an arbitration agreement are governed by its applicable law, namely the law expressly or impliedly chosen by the parties or in the absence of such choice, etc. Obviously, we do have a choice expressly made by the parties here, which is California law, and we know that that is to apply to any consideration of the material validity, scope and interpretation of the rule. And so that is where we start, and the learned judge at paragraph 54 of the judgment says that this rule appears more relevant because his reasoning is the issue in hand is whether the effect of the arbitration provision in the 1997 agreement is such that it binds the claimants. That, it seems to me, falls under the heading of interpretation of the arbitration agreement. That being so, the effect of the arbitration agreement, including the effect of the arbitration provision, is governed by the law chosen by the parties, namely California law. And so, really, as I say, it is quite a straightforward point, because he has before him the question of who is bound by the arbitration agreement, and he says he's looking at the issue of the interpretation of the arbitration agreement. It may be that one could say, well, he's also looking at the scope of the arbitration agreement, but it doesn't make any difference.
It's
because
not a question
both...
of interpretation.
Pardon?
It's not a question of interpretation.
Well,
I mean, taking your two, my lord put to you that there were 2 points. You need to win on both points a few minutes ago. The first is the non-party bound under the terms of the contract, which might be a question of interpretation, probably is a question of interpretation. But then the second, as to whether the burden passes with the assignment of the trademark, that's what the second question is. That's not a question of interpretation of the agreement, is it?
well, I think when we come to look at the the evidence of California law, Mr. Lewison, who was our expert, did refer to clause 12 in looking at that point, because that was a relevant consideration. But
I suppose the clause has said this agreement binds Lord Justice Snowden. As a matter of construction, it would be absolutely clear.
Well,
that can't be the answer. The question is, what effect would Californian law or some other system of law give to such a provision?
Well, my lord, I'm certainly prepared to accept that it falls perhaps more naturally within scope and possibly within the question of the issue of the party to the agreement, or the parties to the agreement, which I'm going to come on to in a moment, because in fact, as my lords have already seen in the supplement to Dicey, Dicey also says that the law of the agreement is relevant to the issue of the party. Yeah. But it's useful to go on and have a look in Dicey at paragraph 16008, which is on
Shall
page...
we do that at 2 o'clock?
Yes, good idea.
2 o'clock.
Okay.